April 24, 2023. May 15, 2023. Examsim 2. In a foreclosure action, the defendant's case can be based on any of the following except, the maker impulsively signed the note. Incapacity, if the maker is a minor or an incompetent. Secret material changes in the note. Forgery, if the maker did not really sign the note. Answer, the maker impulsively signed the note. If a broker exercises her option to purchase some land, she would be considered a principal. Why is next questions tricking me in thinking of personal property? But that the word is real property. Stay alert and focused on the real word. Real property. Which of the following is considered real property? Tenants' fixtures, implements, area rugs, light fixtures. Answer, implements. Fruiticus. The statement signed by the mortgagee which acknowledges that a loan has been paid in full is called what is a satisfaction of mortgage. Satisfaction of mortgage basics. When a mortgage is paid in full, a satisfaction of mortgage document needs to be completed and submitted to clear the title to the property. This releases the lien on the collateral, often the property, used to secure the loan. A takeout loan in real estate financing is, what is a long-term loan to replace a construction loan? Takeout loan is a long-term loan. It is a permanent mortgage loan which a lender agrees to make to a borrower upon completion of improvements on the borrower's land. The proceeds of the loan are used principally to pay off the construction loan, who may make withdrawals from a broker's trust account. What is the broker or a designated other? As long as the person has the broker's authorization, a licensed salesperson or a broker may make withdrawals. Additionally, an unlicensed employee of the firm may also make withdrawals if he or she has a fidelity bond at least equal to the maximum amount to which that person has access. The liquidation of a financial obligation on an installment basis is commonly termed, what is amortization? Amortization is the liquidation of a financial obligation in installments. A husband and wife want to buy a lot for $25,000. They will pay $10,000 cash and the seller will carry back a note and trust deed for the balance. They intend to build a home on the lot in 5 years. When they are ready to look for a lender that will finance their construction plans, the absence of which of the following clauses may cause them difficulties? What is subordination clause? A subordination clause in a mortgage usually says that all original claims on a debt must be paid before any new ones. A subordination clause in a second or third mortgage gives the first mortgage priority. This means that if the house is sold or foreclosed upon, the debt owed under the primary mortgage gets paid off first. When this husband and wife try to build a house, their lender will likely require the seller to include a subordination clause in the agreement for the lot sale. If the lender for that transaction doesn't agree to a subordination clause, the couple may have a hard time getting a loan to build. When loaning money to 2 or more co-borrowers on a single promissory note, the lender would be best advised to increase the security on the note by inserting which of the following phrases after the names of the co-borrowers. What is jointly and severally? If there are multiple debtors on a note, the lender would be advised to put the phrase jointly and severally in a note. In California, one must use another's land openly, notoriously, and continuously for at least 5 years to obtain an easement by prescription. An instrument which protects the insured party against losses resulting from undiscovered defects and encumbrances such as forgery in the record is title insurance. Sherman Antitrust Act prohibits monopolization or attempts to monopolize any part of trade. Real estate instruments, such as deeds, mortgages, leases, easements, and court orders, are recorded in the county in which the property is located to give constructive notice to the world of an interest in a particular parcel of real estate. The purpose of the assessment roll is to determine the tax base for property taxes. In real estate transactions, a real estate salesperson has a direct fiduciary relationship to the sponsoring broker. The rate refers to the rate of return used by investors. The trustor is the borrower who holds equitable title to the property. The neighbor would not be subject to liability under the Federal Fair Housing Act of 1968 in the given scenario. On the California real estate exam, you may be tested on different types of tax exemptions related to real estate, such as 1. Homeowner's exemption. This exemption reduces the taxable value of a primary residence by up to $7,000 for qualified homeowners. 2. Veterans exemption. This exemption is available for veterans who are disabled or over the age of 65, and it can reduce the assessed value of their property by up to $4,000. 3. Senior citizens exemption. This exemption is available to California residents who are over the age of 62, and it can reduce the assessed value of their property by up to $137,000. 4. Disabled persons exemption. This exemption is available to California residents who are totally disabled, and it can reduce the assessed value of their property by up to $150,000. 5. Church property exemption. This exemption is available for properties used exclusively for religious purposes and can reduce the assessed value of the property by up to 100%. It's important to note that tax exemptions can vary by county and may be subject to change. CPMs are designated by the Institute of Real Estate Management, IRM, which is a professional organization for real estate managers. The deed of trust is considered to be a security for the debt. It is a legal instrument used in real estate transactions, particularly in mortgage loans, where it serves as a security interest in the property being mortgaged. The deed of trust is used to provide evidence of the debt and to establish the rights and obligations of the borrower, mortgager, the lender, mortgagee, and the trustee, a neutral third party. It creates a lien on the property, which can be foreclosed upon if the borrower defaults on the loan. While it is related to the conveyance of legal title, the primary purpose of the deed of trust is to secure the debt rather than transferring ownership of the property. The class of individuals protected under the Equal Credit Opportunity Act, ECA, but not under the Federal Fair Housing Act, FFHA, is marital status. The ECA prohibits creditors from discriminating against applicants on the basis of certain protected characteristics when granting credit. These protected characteristics include race, color, religion, national origin, sex, marital status, age, provided the applicant has the capacity to contract, and the receipt of public assistance. Therefore, marital status is specifically protected under the ECA. On the other hand, the FFHA prohibits housing discrimination based on race, color, religion, sex, national origin, familial status, and disability. Marital status is not explicitly included as a protected characteristic under the FFHA. However, it is important to note that some state or local fair housing laws may provide protections for marital status or other characteristics not covered by the federal FFHA. When receiving stock in a cooperative, you typically become a shareholder or member of the cooperative corporation. As a shareholder, you don't receive a deed to a specific unit but rather an ownership interest in the cooperative as a whole. Shareholders have the right to occupy a specific unit within the cooperative building based on the terms outlined in the cooperative's governing documents and bylaws. In contrast, when receiving a deed in a condominium, you become the owner of a specific unit within the condominium development. The deed establishes your individual ownership of the unit, typically along with an undivided interest in the common areas and amenities shared by all unit owners in the condominium. In California, the statute of limitations for an action on a written contract is generally 4 years. The term realtist is typically used by members of the National Association of Real Estate Brokers, NAREB. A tax levy on real property for government improvements such as curbs, sewers, and sidewalks is commonly known as a special assessment. A legal description of a property based upon points of beginnings, distances, directions, and degrees is commonly referred to as a metes and bounds description. This method of describing a property's boundaries involves identifying a starting point, point of beginning, and then describing the property's boundaries by specifying distances, directions, and angles. The description typically includes landmarks, such as physical features or monuments, to provide reference points for the property's boundaries. Metes and bounds descriptions are often used for properties with irregular shapes or in areas where a more precise description is required. The Public Land Survey System, PLSS, or the Rectangular Survey System. Under this system, land is divided into townships, ranges, and sections, forming a grid-like pattern. Each township is typically 6 miles by 6 miles, and it is further divided into 36 sections, each covering approximately 1 square mile. The PLSS is used to describe and locate land parcels in many parts of the United States, particularly in areas that were historically public lands. Lot and block is a method of property description commonly used in subdivisions and urban areas. In this system, properties are identified and described based on their specific lot and block numbers within a recorded plat or subdivision map. A recorded plat or subdivision map is an official document that details the division of a larger tract of land into individual lots or parcels. It is created by a developer or surveyor and is recorded with the appropriate government office, typically the county recorder's office, to establish a legal record of the subdivision, property ownership and land use controls and regulations. 27 total questions. 26 correct, 1 missed. One of the appurtenances to a parcel of land would be, correct answer, bundle of rights, not easement and gross. Rationale: the bundle of rights are legal rights conferred to owners of real property, including the right to mortgage, sell, lease, improve, enjoy, and use the property. They run with the land, and thus are pertinent to it. A bill of sale is an instrument in writing that transfers ownership of tangible personal property, not real property. Laws of agency. 18 total questions. 16 correct, 2 missed. An agency relationship can be terminated in all of the following ways except, correct answer, except estoppel, not destruction. Rationale: if the property is destroyed, so is the agency agreement. If the parties become incapacitated, the relationship ends by law. We can create relationships by estoppel, but they cannot terminate in this way. Honeycomb, an actress from Hollywood, hires a real estate agent to list the property that was the subject of the estate of Hannah Has Been. When Miss Combe signed the listing agreement, she did so as the administratrix. How did she get that title? Correct answer, she was appointed by the court. Not the will made the appointment. Rationale: in a will, a testator can appoint an executor or executrix if the will did not mention one. The court must appoint an administrator or administratrix. Transfer of property. 13 total questions. 10 correct, 3 missed. A standard policy of title insurance protects the buyer against what? Correct answer, recorded documents, not unrecorded documents. Rationale: a standard policy of title insurance protects the buyer against all recorded documents affecting the title. Once a person has gone to the courthouse and reviewed all documents pertaining to the property he intends to buy, he is said to have, correct answer, actual notice, not constructive notice. Rationale: the law holds that everyone has constructive notice, or presumed knowledge, of recorded documents. Once you actually have seen the documents that pertain to ownership of the property, you have actual notice. Caveat emptor refers to let the buyer beware of physical defects in the property and has nothing to do with the title search. Insurance policy premiums are prorated from the date the policy is, correct answer, assigned. Not written. Rationale: if a loan is being assumed, an insurance premium is prorated at the date of the assignment, that is the date of closing. Practice of real estate and mandated disclosures. 36 total questions. 30 correct, 6 missed. How much can be paid on behalf of the licensee out of the Real Estate Recovery Fund per licensee? Correct answer, $250,000. I said $50,000. Rationale: although the fund can only pay $50,000 per transaction, it can pay up to $250,000 per licensee. A salesperson presents a full price offer from a financially qualified black prospect. Later, the salesperson's broker presents a lower offer to the same seller from a white prospect. The seller accepts neither of these contracts but sells to a neighbor, through the same salesperson and broker, who decides to buy the house to prevent the black prospect from purchasing the property next door to him. Which of the following parties would not be subject to liability under the Federal Fair Housing Act of 1968? Correct answer, the white prospect. I said the neighbor. Rationale: no person is allowed to be a party to a plan of discrimination. The neighbor, the salespersons, and the seller were all part and party to a plan of discrimination and thus are subject to liability under the Federal Fair Housing Act of 1968. The white prospect simply submitted an offer, and is not liable. All of the following documents must be approved by the Real Estate Commissioner prior to use except, correct answer, independent contractor agreement. I said mortgage loan disclosure. Rationale: documents we execute with clients must be approved by the Department of Real Estate. Documents between brokers and salespeople do not. During the sale of a property, who would an agent and client negotiate with? Correct answer, customers. I said agents. Rationale: the broker and the principal negotiate with third parties, also known as customers. When the seller asks the broker to keep a latent defect to herself, the broker refuses. What code contains the ethical guidelines for the broker? Correct answer, Business and Professions Code. I said NAR Code of Ethics. Rationale: a broker would rely on the Business and Professions Code of Ethics. Which of the following could a real estate agent lawfully prepare? Correct answer, none of the above. I said lease with option. Rationale: all of these documents must be prepared by an attorney at law. Contracts. 18 total questions. 15 correct, 3 missed. Seller sue promised in the sales contract to have an expensive new roof put on the house before closing. At the closing table, when asked about the roof, Sue said she decided not to replace the roof but just to reduce the sales price instead. What can Bill the buyer do about this? Correct answer: either answer. I said refuse to close. Rationale: if one party to a contract performs his or her side of the bargain as set forth in the agreement, the other party is required to perform. 2. If one party fails to perform, and the failure is not excused, he or she has breached the contract and the other party is not required to perform. If seller Adams simply decides not to go through with the closing on a sale to buyer Williams, what can Williams do about it? Correct answer: sue for specific performance and for damages. I said nothing, because the deal has not yet closed. Rationale: a successful lawsuit for specific performance may compel Adams to perform his responsibilities under the contract, including transferring title to Williams. In addition, if Williams can prove other damages due to Adams' refusal to perform, Williams may also sue to recover those damages. If the contract was executed, completed, Williams had obtained equitable title, and it would not matter that closing had not occurred. A lease executed by a minor lessor is, correct answer, voidable by the landlord only. I said void. Rationale: the minor is the landlord in this question. A lessor is the person who gives the lease. The lease is voidable by the minor landlord, who lacks contractual capacity. Void means the contract never existed. The voidable contract is enforceable only as long as the minor so chooses.